Finality start. In the present case, as already noted, the children of the family were taken out of the matrimonial home on 17/9/2003, which to my mind was an act of interparental kidnapping and cannot deprive Delhi courts of the territorial jurisdiction to entertain a petition on appreciation of provisions of law and the facts of this case. It is seen that the child is under the custody of the maternal grandmother because of the compelling circumstances. However, for the welfare of the child, the custody of the child can be taken by the person who is interested in the welfare of the child. The maternal grandmother in whose custody the child has been kept is taking care of the child and also filed an application demanding maintenance from the father for the welfare of the child. The respondent number 3, Srimati Hussain Bano, has stated in the Wakalatnama and in her application under section 125 CRPC that she permanently lives at Sikar and presently at Bombay. The living for certain period at certain place cannot be construed to be the ordinary residence of the minor. The Andhra Pradesh High Court in the case titled Harihar Prasad Jaiswal versus Suresh Jaiswal and others has dealt with the expression place of ordinary residence and observed as under. If the expression place of ordinary residence means the residence of his natural guardian, the very purpose of using the word the residence of the minor in section 9 would be the natural guardian that given the jurisdiction to the court under section 9(1), but it is the place of ordinary residence of the minor, and the legislative has designately used the word where the minor ordinary resides. Hence, the actual residence of the minor having regard to the circumstances under which the minor happens to reside at a particular place must be taken into consideration in deciding the place where the minor ordinarily resides. In the circumstances of the case, it must be held that the minor has been living with her mother at Nagpur for some time and at Tusmar in Maharashtra state for some time. Hence, the minor's ordinary place of residence cannot be said to be Hyderabad merely because the father, who is the natural guardian, is residing at Hyderabad. Further, there is no evidence to show that the minor was residing at Hyderabad in 1975 when the application was filed. Assuming it to be so, it can only be said to be a place of temporary residence for the purpose of complying with some conditions imposed by the magistrate, and this temporary residence cannot be deemed as the place of ordinary residence of the minor. In these circumstances, the trial court was justified in holding that the court at Hyderabad has no jurisdiction to try the petition and return the same for presentation to the proper court. The ordinary residence of the minor cannot be said to be at Sikar as the child has been shifted as per compulsion and the circumstances created by the mother of the child. The child would have been handed over to the custody of the father, though perhaps the mother might have thought in her wisdom that the child with her mother may be more convenient and looked after well, unmindful of it that the father is the natural guardian of the child. the plea of the learned counsel for the respondents that the ordinary residence is at Bombay is not made out as per their own pleadings, and the record Srimati Hussain Bano, in whose custody the child is resident of Sikar, since the child has been put under custody of the maternal grandmother because of the compelling circumstances. Therefore, it also cannot be said to be the ordinary residence of the minor. Therefore, under such circumstances, I feel that the district court Junjunu, from where the child was taken by the mother from the custody of the natural guardian, has the jurisdiction to entertain the application, as the Junjunu is the ordinary residence of the child. For the aforesaid reason, the order under revision is set aside. The application is remanded back to the district and session judge Junjunu for disposal in accordance of law. Revision petition is allowed. No order as to costs stop.